Welcome to the Divorce Playbook with your host, Frank LaRocca. In each episode, you'll learn about the X's and O's from the professionals who are experts in the area beyond Frank's law firm. You can find this show at www.divorcelawNJ.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, and more. Now, here's the host of the Divorce Playbook, Frank LaRocca.
How you doing? We're here today with Allison Fried. Allison, how'd you like that intro music? Pretty exciting, huh?
Very exciting.
Yeah, this is episode 2, and the biggest complaint so far was that my mom listened to the show last week, and she said during the intro I fell asleep, missed the whole show. So we got to do a little something more upbeat.
I like the AC/DC idea.
I think I'm going with it. Right?
I don't know if there are any licensing issues.
Well, we'll see. You know, they're kind of old, so maybe they'll do me a favor. But Allison works at Capaldi Reynolds. They are a firm that's known to us in the divorce community as people who do the QDROs, right? QDROs, QUADRO. That's how you spell it, right?
We usually say QDRO, but okay. We use necessity.
Right. I know people use the QUADRO, and I said it as a joke. I don't know if you are aware of this, Allison, but prior to me going to law school, I worked for prudential mutual funds when the Tax Reform Act of 1986 came into play. So that's when transfers from retirement accounts went into 401k accounts, went into different pension funds, and, you know, QDROs and understanding what a qualified Q, domestic D, relations R, O, order R came into play, and how they, you know, relate to what happens, you know, upon the termination of plans, upon divorce, and different things. And, you know, maybe one of the things we could talk about, we didn't bring this up before, is that a 401k or a qualified plan is established by federal law. And what kind of a problem does that impose for people who are trying to divide them pursuant to a state court in a divorce case, so to speak?
Well, federal law preempts state law,
right?
And there are anti-alienation clauses in ERISA, which is the law that governs the retirement plans. So you can't technically go into a plan and assign it, a portion of it, to, let's say, a former spouse without some kind of court order. And that's what ERISA created, this option to go in and have this alienation so that you can divide the retirement plan.
Right. So under ERISA, any qualified plan is automatic to the surviving spouse, correct?
Yes. Yes.
Right. And in order to change that, you need to have a qualified domestic relations order, or a surviving spouse can sign a waiver, right?
Correct.
Right. Now, if you're divorced, you lose as a surviving spouse. You're no longer a surviving spouse, so you lose your ability to collect from that plan. And if somebody remarries, the new surviving spouse gets the entire plan pursuant to ERISA, right?
Unless there's a QDRO in place, that would be right.
Unless there's a QDRO in place, right? And that's why one of the important things about the divorce playbook, the X's and O's, has to include a QDRO. And there's a lot of pitfalls in QDROs, doing them, not doing them, when to do them. What does it mean if it's just referenced in an MSA? Is there specific language you can put into an MSA that can potentially be viewed as a QDRO at a later date to protect people? Let's start off with this. What's the difference between a defined benefit plan and a defined contribution plan?
A defined contribution plan has a balance that you can look at, and it's expressed as a dollar amount. Defined benefit plan is a promise for a future benefit. So it's what we would think of as a pension. And it says when you retire, you're going to get X dollars amount per month, for instance.
Right. So even if something, though, is called a pension and profit sharing plan, so to speak, it could still be a balance account, right?
It could be. Yes. It really is in the plan documents that will give you the details of whether it's classified as a defined benefit plan or defined contribution plan.
So let's talk about that. What is a plan document?
It's the legal kind of playbook for the plan, and it talks about all the plan rules and what's allowed under the plan, like earliest retirement age and what the matching contributions are, things like that.
And in the plan document, can it define what happens in a divorce with respect to the non-member or non-participating spouse?
No, I've never encountered it where the plan document says what happens in divorce.
Well, could it say that the alternate beneficiary has to keep their money in the plan as opposed to distributing it out?
Yes, it could say that.
Right. So if you're an attorney or you're a divorce litigant and you believe, you know what, my husband or my wife has a pension plan and I'm going to take my share now and do X with it, right? Even if there's loan provisions that the spouse and the family used in the past, that could be prevented in the plan document. Is that correct?
Most certainly, yes. With the defined benefit plans, most frequently, there's no access for the alternate payee. We call it the alternate payee, the person who's receiving the money under the plan. There's usually no access to that until the earliest retirement age of the participant, the employee.
Okay. And so talking about this plan document, right? One of the things that I have on my chalkboard as to what to do, and I try to figure out by questioning the client, the adversary, if there's a defined benefit plan versus a defined contribution plan. But whenever there's a defined benefit plan or another qualified plan that's not a balance account, one of the first things that I do is try to get the plan document. And you either can do it with a consent for release from your spouse or a subpoena, as long as it's properly served. And one of the things I do with that plan document is, yes, I try to read it, but two, I send it to somebody like you, right, who's got vast experience understanding the nuances of the plan document. What do you think about that? Oh, there's our co-host.
Yes, that's our co-host, Lucy.
Maybe the co-host can answer the question.
Yes, Lucy? No. I'm sorry. So your question was?
So what are the things you look for when you get the plan document?
We look for specifically what happens upon death. So for defined benefit plans, the survivor benefit can be 100%. It could be 50%. I think by law, it has to be at least 50%, but some plans allow it to be higher. Is there a cost to that survivor benefit? For defined contribution plans, we look at what kind of plan it is. If there's a distribution allowed at a certain time, or if it's limited, and if it's limited, whether a QDRO can go around it.
Okay. And let me ask you a question about about a survivor benefit. So let's say there's an example of a case, you get a plan document, you're helping out a firm and they say, hey, listen, we're going to do a QDRO and my client is going to get 50% of the marital portion of the spouse's defined benefit plan. Okay. Nobody says anything about a survivor benefit at all. And you follow instructions. You don't ask questions, which I know you do, but you don't ask questions. And they just did a QDRO for 50% of the marital portion. And in this particular defined benefit plan, the pension, the benefit stops upon the death of the beneficiary, the person who's working there. What happens to the ex-spouse? What happens to that person's share?
If the survivor benefit isn't, if there is no survivor benefit for the former spouse, then the former spouse is out of luck. The order could have been written. In this case, for most qualified plans, you can write the order as a separate interest order, which would allow the former spouse to continue collecting once she starts to collect until until her own death. So the employee's death would not impact her.
Does every defined benefit plan allow a separate interest?
No, some plans don't allow separate interest, and all the government plans don't allow separate interest. For
Right.
government governmental plans, it's only shared interest, which means that when the former spouse can't start to collect until the employee starts to collect. So let's say we have a police officer in New Jersey and he decides, I don't want to start to collect. Well, the former spouse isn't going to get anything.
Right.
So you have to be careful when you're crafting your agreement, because some people will cut off their nose to spite their face.
Yeah,
That's not the expression.
So in the policemen and the firemen and the government, the airline pilots, they have a different plan as well, right? In those plans where it's a shared benefit that starts and ends with the commencement of the benefit and the death of the employee, if there's no survivor benefit elected or specified that goes to the former spouse, it just ends, right?
That's correct.
And if there is a survivor benefit and the former spouse isn't named, what happens to the survivor benefit if that person's remarried?
It goes to the current spouse.
The new spouse, right?
Yes.
So you could have a former spouse married for 25 years collecting $4,000 a month. They can collect that for 1 year. The spouse could pass away, and the new wife of 9 months gets the benefit for the rest of her life.
That's the way it works.
All right. So very important, right? Number one, determine if it's a defined benefit plan or a defined contribution plan. If a defined benefit plan, number two, get the plan document and get it over to a professional who could review the plan document. We're lawyers. We could read it. I actually have some experience in this. You know, a little experience is too much, you know, because then you think you know everything. Get it over to somebody like you to take a look at it and go over all the points, the pros, the cons, and what you should do. A lot of times now, you know, the QDRO company, so to speak, is retained as a joint person. How does that put you, you know, in place when you recognize that there are issues and you really can't advocate for one or the other, but you also have some type of a responsibility to identify the issues? How do you handle that?
We, of course, try to get everyone on the same page before we draft an order. And often that's not possible. And if it's not possible, then often people end up back in court litigating the issues that weren't addressed in the initial, let's say, agreement, if there was an agreement about what needs to be incorporated into the order. So it's good to know when drafting the agreement what points you really want to hit in the agreement so that there aren't any surprises later when it comes time to draft the order.
And here's the timing question. This is something you and I talked about before the show. When do you do the QDRO, right? When is it done? So if you just typically put the language in the MSA, my client will get 50% of the marital portion of the such and such pension plan, and don't have the specifics in. And even before you draft the order, you do your typical punch list after you review the plan. Hey, is there a survivor benefit? Is there this type of appreciation? Are you doing a separate interest? All the different identifying things. The agreement could be done already. Somebody didn't realize that they had to deal with this exact issue we talked about, the survivor benefit. And there was a question there on the cost of that. And they could be back litigating post-judgment. And I know you have experience in this as I do. Is it easier or harder to modify language in agreement prior to it being signed or after it being signed?
Much easier prior.
So wouldn't your advice, and again, this isn't to really just drum up business, I think we gave a couple of examples. Wouldn't your advice to practitioners and clients who are saying, oh, my lawyer said they're not getting involved with the QDRO, wouldn't the advice be figure out what your rights are under the plan and determine what you want to negotiate prior to finalizing your agreement? Isn't that an important tip?
Most definitely. It's very important to incorporate all those points that need to be addressed in the QDRO into the agreement. The agreement itself, if it's specific enough, could serve as the QDRO.
So there's this other situation, right?
Right.
You put in your agreement subject to a QDRO, and the QDRO is not done. And then the person passes away and is remarried.
And that goes back to what we said before. The former spouse could be out of luck, even though she was expecting to collect for a long time, a significant amount.
So let's even change that. Like, let's change that hypothetical. It's a 401k, right? The parties are 45 years old. Nobody's needing or looking to take money out of the retirement account that has $2 million as the marital share, right? And they agree 50% of the retirement account subject to a QDRO that's going to be prepared by, somebody at a later date. That they don't really specify and have it done. And the parties move on with their life. They go to graduations. They go to grandchildren, stuff. They're in their late 50s, early 60s. Nobody's retired yet. And the person who's got their 401k that now has $3 million in it just from growth passes away but is remarried. What can happen if the language in the agreement, the MSA, isn't specific enough to be qualified as a domestic relations order?
It's possible that the former spouse could lose the right to receive that benefit.
Right.
Luckily, we've encountered this situation many times, not luckily that someone has passed away, but luckily that the plan will still honor a non-pro-tunc QDRO, for instance, or just one for survivor benefits that would allow the former spouse to get her share.
So non-pro-tunc QDRO, right? Now, I guess you can go to court and have a court order, it's a domestic relations order, non-pro-tunc. But what if, you can't convince the judge that was appropriate and the estate doesn't agree that that's appropriate and you can't do a non-pro-tunc QDRO? Can the plan just elect to distribute it anyway?
It's really going to be governed by their document. And I think there's not a lot of litigation about this. And I think there's even a Supreme Court case that has made some decisions in this area.
All right. So the better view, right, is if you have a QDRO or you're mentioning a QDRO in your agreement, either have it done and prepared prior to the divorce or make sure that the client understands that they need to do it if you're not doing it, after the divorce. Is that
absolutely? A lot of people don't realize that for QDROs, parties don't have to be divorced. An alternate payee under a QDRO can be a spouse or a former spouse, a child or other dependent. So there's no need to wait until the divorce is entered. Once you have your docket number, you can enter a QDRO.
Right. So, and it's not really common practice to do, but, I'm just going to tell you from my experience, I was sufficiently spooked by a case that came out maybe 15 or 20 years ago. It was called Ross versus Ross, where the surviving spouse did not have a QDRO in place and lost the benefit completely to a new spouse. And realize that I'm putting in my agreements like everybody else, subject to a QDRO, and then I'm closing out the file. And if somebody passed away, what's my obligation as your attorney to make sure the QDRO is entered? And when I looked at my prior retainer agreements, I was obligated. So I made an election early on to specifically carve out the preparation of any QDRO and made it subject to a separate retainer agreement. I think that's a conversation that a lawyer can't just throw in their retainer agreement. They really need to have that conversation with their client and give them the ability and help them pursue obtaining a QDRO. As long as they agree on the terms, getting it done even contemporaneously with the divorce. Parties can retain services of your firm or firms like yours to prepare these. And it's really not much lawyer input, just review. You find that?
That's correct. Do many lawyers do that in practice? In my opinion, no. But it's certainly a convention that I would support going forward. That attorneys handle it that way. We get a lot of litigants calling us saying, "I don't know if this was ever done. I don't know what my rights are. I don't know if my attorney's still representing me." So I would say have your retainer agreements really be specific as to what the attorney's obligated to do versus what the litigant has to do once the relationship ends.
You have any tips with respect to what should be included in a marital settlement agreement?
Well, for a defined contribution plan, I would say always put, I would say, defined contribution or defined benefit plan, put the formal plan name in there. And that would help you, if necessary, have the agreement serve as a QDRO. For a defined contribution plan, deal with how you're going to treat an exempt balance if there is one. Is there an exempt balance? What is the valuation date? Is there going to be an adjustment for gains and losses? If there was an outstanding loan, how is that going to be handled? If there is a fee for processing the QDRO, how is that going to be handled? Who's responsible for preparation of the order? That's defined contribution or defined benefit. For defined benefit plans, I would say address whether it should be a separate interest or a shared interest order. We talked about for the governmental plans, it has to be a shared interest, but for someone who's not retired for other qualified plans or for qualified plans, they can be shared interest or separate interest. So it's important to, that's often a places where heads butt. So I would say put in your agreement whether it's going to be a shared interest or a separate interest. And there's advantages and disadvantages to each party for each. Is the alternate payee going to share in cost of living adjustments? Is the alternate payee going to share in early retirement subsidies? What is the survivor benefit? Is it going to be for the marital portion of the survivor benefit? Is the going to be for 100% of the survivor benefit?
Is there a cost for the survivor benefit?
Is there a cost for the survivor benefit?
Who's paying for it?
Exactly.
But sometimes there's a survivor benefit and the dependent, so to speak, spouse is saying, well, listen, I want that. And the cost for that survivor benefit is going to mean a reduced payment on a monthly basis to the person who's retiring.
Yes.
So who's paying for that? Is there going to be a reduction? Is that going to be equalized? Is that going to, how is that going to be taken care of? And that's something people, sometimes they agree that there's going to be a survivor benefit. And then let's say you represent the party who's employed. They say, well, that just cost me $180 a month. You never told me that. Mm-hmm. Things you need to explore. So
some plans will allow you to split the cost of the survivor benefit. For the military, for instance, though, they won't. It comes off the top, and if you want the alternate payee to absorb the whole cost, you have to kind of circumvent the rules so that the alternate payee gets a lesser percentage of the monthly benefits, so that she's basically paying for the survivor benefit.
Right. There's certain plans, and I think it might be the air traffic controller plan where I believe this is the rule. You might remember, you might not know, but if you say your client is going to get $5,000 a month and you don't indicate a percentage, the rule is if you don't indicate a percentage, it's 50%. Does that sound familiar to you?
Well, the air traffic controllers would be under the Federal Employees Retirement System, and they have their own special rules. I wouldn't put it. It doesn't sound so much in left field that could be the case. There's a lot of, for the Federal Employee Retirement System, we call it FERS. There's a lot of kind of, if you don't include this by default, it's in there.
Right. Yeah. So we ran into something like that in the case that I had. And it was, if we put the dollar amount and the retirement, the plan said, Mom, you didn't give us a dollar amount. It's 50%. And we had to go back for post-judgment litigation to demonstrate that the dollar amount versus 50% was inequitable. I said we had to have the court modify the marital settlement agreement. In that case, we were successful. But if we weren't successful and we represented the quote payer, we'll call it, then we would have committed malpractice and our client would have lost a large amount of money, and he retired early for 20 some odd years. And that could be a significant hit. So again, for me, getting the plan document, bringing somebody on board to talk to you about the pitfalls and the benefits, or advising the client that they're quote unquote on their own unless they sign a separate retainer, if they're going to wait till the end, or something that a lawyer can do to protect themselves. Is it a disservice to the client? It is if you don't explain it to them. If you explain to the client, like, listen, dealing with your retirement account in and of itself could be $2,000 or $3,000 in legal fees. So So if you retain me to do that, and at the end of the case or towards the end of the case, we're going back and forth about these specific clauses that are going to be in your document, and the bill is significant, you have to understand that we're going to be expected to pay that. And if Mary down the street or somebody in your group chat said they paid $500 for their QDRO, it doesn't necessarily apply to you. And those are tough conversations to have, because people coming into divorce are spending so much money, losing half of their assets, not seeing their kids. They don't want to hear that their lawyer is going to charge them an extra $3,000 to get them something that they believe they're entitled to. But the point for lawyers is to have that conversation. That's what I think is key.
I would agree. And I think people don't realize the magnitude of some of these decisions that are being made now. And like someone said, my neighbor got it done for $500. Well, sometimes you get what you pay for. So, there's services that will basically just fill in the blanks. And then there's services that will try to interpret the agreement. And for instance, we will even review the agreement before it's entered to make sure you hit upon all the points you really need to hit for a certain plan. And I know other QDRO preparation companies do that as well.
The balance accounts, the 401ks, there's some little things that you got to be careful. But with the defined benefit plans, you really, everybody, client, attorney, accountant, friend of somebody getting divorced, have your friend, your client, your lawyer get the information, get the plan document, get it to an expert like Allison to review, and even can be done jointly. Raise the questions. Both sides need to know, right? It can end up meaning more or less money for one or the other. But what are the points that the two of you, if you're in a joint situation, need to have figured out prior to entering into your marital settlement agreement? That's one of the biggest tips I have. Do you have any other words of advice we can give people?
Well, I would just like to go to that point. Often people don't realize what the QDRO says until someone's retiring. So it's good to understand what's being assigned when the order is being entered. Otherwise, there's often surprises, and people think it's inequitable. But if the agreement says it's supposed to be this way, it's not inequitable because it's already been decided. And I know with one of the lawyers in your firm, we had an encounter where the former spouse was very adamant. This isn't the way it's supposed to be prepared. This isn't the way it was supposed to be prepared. And I was so comforted by the agreement that the lawyer had crafted, because it absolutely addressed this is the way it was supposed to be prepared.
Right.
So I think if you deal with it now, it's going to prevent problems later.
All right. So listen, Allison, I want to thank you for coming on the show. And Allison, again, works at Capaldi Reynolds, very well-known company. You can Google Allison Fried, Lois Fried, Capaldi Reynolds. They do a really, really good job for you. If anybody has any questions, you can reach out to me or to Allison, and we'll try to steer you in the right direction.
Thanks so much.
Thank you.
You've been tuning into the Divorce Playbook with your host, Frank LaRocca. To review the X's and O's of your divorce, Frank's law firm can help you. You can find this show at www.divorcelawNJ.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, and more. Thank you for your positive feedback, comments, questions, and for sharing this show with others.